Good afternoon, good evening, good morning, depending on where you are on this fast forward planet, which is wrapped in so many layers of turbulent change. I stopped listing them. I'm Andy Revkin. This is a Sustain What show that I've been doing independently from down East Maine for a number of years. Started in the pandemic, trying to make sense of complicated issues through conversation. And the endangerment finding that uh, was a ruling at the EPA in 2009 is being repealed, or the effort is underway by the Trump administration. This has created all kinds of reverberations and ripples. It's end times for some. It's time for champagne for others. And I thought it would be great to kind of get at the legal aspects. I did a show a week ago more about this sort of technical and science sides with um, um, uh, Gernot Wagner at Columbia. But this is all mostly about the law. I mean, it's really all about the law. So I reached out to Jonathan Adler, who's been writing. I don't know if anyone has dug in more deeply for longer on this issue than you. Probably, maybe, I don't know. But you're really you really got this nailed down in so many ways. You come at it from a standpoint of, I would say you're a fan of limited regulation. Is that a way to put it?
That's fair.
Would you libertarian? Is that
Classical liberal, whatever. I am certainly not a fan of regulation generally, and I've certainly been very critical of using federal regulation as the primary tool to address climate change as well. Um,
right?
sure.
Yep. And we have Sean Donahue, who just came on very short notice, who's part of a big crew of lawyers who are working with the Environmental Defense Fund and the other American Public Health Association, other plaintiffs in a lawsuit that's been filed. And that's taken this back into the arena where it just lives perpetually, the arena of courts. And Gene Chemnick at E&E News, Politico, is here, and it's really wonderful to have you back. We were talking about that play about climate diplomacy
Oh yeah,
a
yeah.
while back, and but here's a new drama. I mean, just to anyone who's involved, it's a drama. To a lot of other people, it's kind of like, oh, what is this? So let's start with the what is this endangerment thing, just very briefly. Maybe Jonathan, you could just sort of give your thumbnail sketch of this, what this allowed the EPA to do and what it means.
Sure. So there are multiple provisions in the Clean Air Act that obligate the EPA to take certain regulatory steps if the administrator is able to reasonably conclude that emissions from particular sources cause or contribute to pollution, which can be reasonably anticipated to threaten public health or welfare. It's more or less the language. I garbled one or two of the words, but the idea is that this assessment by the administrator that emissions cause or contribute to pollution that threatens the public health or welfare is what's often been characterized or shorthanded as endangerment. And the idea is that this finding is kind of a trigger that then results in regulation. And so in the case of Massachusetts versus EPA, which was a lawsuit arguing that the EPA had authority that it had renounced or disclaimed, but had authority to regulate greenhouse gases as pollutants under the Clean Air Act. As a consequence of that decision, the EPA felt that it had to decide whether or not greenhouse gases cause or contribute, or greenhouse gases from mobile sources in this case, cause or contribute to pollution which can be reasonably anticipated to threaten public health or welfare. And the Obama administration made that finding and then used that as the basis to adopt greenhouse gas emission standards for motor vehicles. And then because there is parallel language in other parts of the act, it allows for similar steps. Perhaps one could even say compels similar steps under other provisions of the act. And for some, this kind of threshold role that the endangerment finding plays in kind of requiring or unlocking EPA authority to address greenhouse gases under the Clean Air Act has made it a target. I think I've characterized it as the great white whale of climate policy for folks that don't like climate policy or climate regulations, and that's what the Trump administration is trying to do. Is trying to basically take out the foundation or that the legal foundation upon which utilization of the Clean Air Act to address greenhouse gases sits on, rather than trying to go after each regulation one by one, or by just reforming or modifying the particulars of existing regulations, kind of knock the legs out from under them in one fell swoop. And I think from their standpoint, create conditions that would prevent the readoption of such regulations in the future.
And you've written a lot. You were kind of writing a lot of sort of warning shots, saying, "Hello, administration. Hello, Heritage Foundation. Hello, everybody." There's a lot of reasons why this might be a misstep in the long run.
Right. I mean, legally, I think it rests on some arguments that are either, in my view, not particularly compelling, or arguments that the Supreme Court has rejected. So that it's hard to make the arguments they're making and think that cases like Massachusetts versus EPA, but not just Massachusetts versus EPA. I mean, Sean and I will probably agree that there's a much longer history of court decisions thinking about the Clean Air Act and the way it works. Admittedly, not all of them in the Supreme Court. Some of them are lower court opinions that really make it hard to make some of the arguments that the administration wants to make. I also thought, as many thought, that going after the endangerment finding, because of the legal difficulty of doing it purely on legal terms, would encourage trying to make a scientific argument that the administrator could not reasonably anticipate that climate change threatens public health or welfare. And that's also, I think, a hard argument to make, especially the way this language has historically been interpreted. So I felt that even if one accepts the kind of deregulatory priorities of the administration, it's hard to justify this particular strategy. And then there's a separate issue of what the motivation of the strategy is, and is this about sound climate policy, or is this about something else? And
yeah.
I think it's fair to think that, at least for the current administration, it's about something else. But that's in my writing, I tried to focus on, okay, let's assume the goal is deregulation. Is this a serious, intellectually coherent, effective way to do that? And I'm skeptical.
Well, that must sound good to Sean. Although my first question would be, why aren't they listening to you? And I guess this gets to your point about they have other motivations.
Well, and it's the great white whale. I mean, I like the great white whale formulation in that, there are folks, including some folks in the administration, who were part of the legal teams involved in Massachusetts versus EPA on the EPA side back then in the Bush administration, who just don't want to accept that case and those holdings, and so kind of are looking for ways to undermine it or challenge it. There are folks, as we know, that can't accept the idea that climate change is a serious policy problem that requires serious attention, and so the endangerment finding, I think, symbolizes a lot of that. I mean, this goes back to the whole red team, blue team idea that we saw in the first administration, the Department of Energy report. I mean, there are certain folks for whom this is just, it has totemic significance, apart from the policy merits. Because the other thing I didn't mention is, the threshold policy question right here is regulation of mobile sources. And, Sean and Gene will correct me if I'm wrong on this, but I don't think any of the automakers have yet indicated support for this particular attack. I mean, they certainly may have concerns about some of the mobile source regulations and wishing they were a little more flexible or longer timeframes or a little less stringent and so on. But it's not like the automakers have been out there complaining, oh wait, the endangerment finding is a real problem for us, please get rid of it, please make all of this go away.
Right.
Their position, at least from my perspective, it appears to have more been, go a little easier on us, make it be a little more flexible, but this general path is something we're not as worried about as perhaps other regulations or other effects on their cost structure.
So, Gene, I want to bring you in, and then Sean. Sean, I'm sure you have a lot to say, but Gene too. Gene, you're reporting on all the dimensions of this, not just the legal. When you hear what Jonathan was saying about other motivations, or why is this such a target for a certain crew of the Trump team? Do you hear directly of what the shape of that is, that white whale? What are the motivations? How much of this is symbolic? How much of it's just appeasing Trump, who has got such a cartoonish approach to so many things, or something else?
I mean, I've been really curious why they're pursuing this for a long time and who the personalities driving it were. We kind of knew it wasn't coming from EPA or even from the political staff at EPA. And obviously there was this parallel effort to go after the science that lived at DOE. So there was some interest in whether maybe it was Chris Wright, driving some of this. I had heard that he was sort of working the phones early in the administration to try to drum up some support. But I'm not even there was that cadre of scientists that they brought in, and then of course I think. What Jonathan was just alluding to is OMB, is Jeff Clark and co at OIRA, who Jeff Clark, was at DOJ during the Bush administration, and in fact argued the case before the DC Circuit, and apparently has always been interested in getting it overturned, Massachusetts versus EPA. So I don't know. I'm still interested in exactly the mechanics. There was a great New York Times piece that I will credit that we all read about Clark and Russ Vogt and
Right.
to Mandy Gunasekara and Jonathan Brightbill, who apparently had been working on this sort of pre the beginning of this administration and going back several years. And I'm so curious to find out whether the substance of what became the endangerment finding repeal was created pre-administration.
Right.
Yeah.
Was this a big part of the Heritage, the Project 2025 agenda?
Well, I guess that it's related to that because, according to the New York Times, Mandy and Brightbill got funding apparently from the Heritage Foundation for this initiative to write text and to perhaps do a review of the science that was sort of laying the groundwork for, endangerment in a potential second Trump term or Republican term. And yeah, I mean, I think that she of course authored the chapter of Project 2025 on EPA, and she does mention going after the endangerment finding, but I don't know what the mechanics are there. I would be so interested to know, and if anyone knows, I would very much like to be told.
Okay, well, we'll
together.
see.
Yeah.
I'm going to just quickly. The Heritage Foundation has been boosting this for a long time. This was Facebook last year. I don't know if the sound's going to work. I'm having some technical issue with StreamYard, but this was something they posted on Facebook and everywhere. Great news. This was when the initial plan to unendanger the EPA came out, and so they're pushing this. That we're making the point that this is about the science. That science has changed. The warming, the trajectories for emissions and stuff are different than they were et cetera. So they're making a lot of noise about this, and that maybe takes us to you, Sean, in terms of your, going back to what I was asking Jonathan initially. If maybe you could just tick down some thoughts you have on the state of play, and if this is an ill-advised strategy from a strictly legal standpoint. Do you have your own sense of what's going on?
Yeah, I mean, I think it is ill-advised. I don't think it's a sound decision on the law or the record. Unsurprisingly, given my work, but I think I would say that if I were an academic or otherwise, there was talk of maybe doing this during the first Trump term. There were advocates of going after the endangerment finding, and that didn't happen. I think a lot of it was because of the sense that it was legally very difficult, and also that the ocean of scientific evidence, as the DC Circuit described it, supporting the finding was very large and formidable. And industry was not pushing for it. And in fact, key industries like power and automobiles were opposed to taking that step. And in fact, the first Trump administration actually adopted regulations for both power plants and motor vehicles that were based on endangerment findings, even though they were considerably weaker than environmental groups believed were warranted. They were based on that finding. I think the fact that they made this effort to go after the science, it was procedurally very irregular. My client, Environmental Defense Fund, and Union of Concerned Scientists brought a lawsuit because the effort to create this committee of scientists who are going to call into question some of the basics was done without regard to federal law on openness and transparency of advisory committees. But then also just the substance of the report that they came up with was attacked by by many climate scientists, including many whose work was cited, and said, you've got it wrong. And in fact, the science has gotten stronger, more compelling. The problem is getting worse, and we know a lot more about it than we did in 2009. So that sort of branch, I think, as could have been predicted, was not likely to be successful, and that has been largely eliminated from the final rule. Although one can say that a lot of the sort of theory of the repeal is hard to justify if you believe the science. It's not clear it's sort of a rational thing to do without believing that climate change is not really a big problem. And then on the law side, I think for reasons Jonathan said, I think it really is in the face of, or in the teeth of, the Massachusetts versus EPA decision. The final rule comes up with some sort of what might be described as highly technical or even hyper technical arguments that, well, Massachusetts didn't exactly decide that we have to regulate motor vehicle emissions, but it's very hard it's sort of like a clever argument that you might give a half an extra point in a law school exam for coming up with, while urging the young lawyer not to raise it in court because it's too clever by half. I think a lot of the final rule has that character, that not only Massachusetts, but there are a set of Supreme Court decisions following it that sort of relied upon Massachusetts. The DC Circuit, of course, upheld the 2009 endangerment finding. There was an effort to get that put before the Supreme Court. The court denied cert on it. So there's just an awful lot of water under the bridge. And there's the fact that we have a decade and a half of experience with greenhouse gas regulation of motor vehicles, and the world has not come to an end. The auto industry continued to grow. So some of the flavor of this final rule is the sort of major questions idea that this is so sweeping and big that there had to be something more specific in the statute. I think it's very hard to maintain that kind of argument where you have a bunch of law that has grown up based on the initial Massachusetts decision and the initial endangerment finding, and then you have actual experience that this is a workable kind of regulation. So I do think it faces tremendous difficulties. I don't think it's a sound decision. I think it's better explained as part of this kind of political, some of the language, extraordinary language the administrator used about driving a stake through the heart of the climate religion. Like, that's not the language of someone who's trying to kind of make technical arguments based on enacted statutory text or record that is about dancing on the grave of your political opponents and relishing the lamentations of your political adversaries. And I think there's a lot of that. Obviously, the language about climate change being a hoax, and some of the other truly breathtaking things the administration's done in this area. For me, the purporting, at least, trying to pull us out of the Rio Convention, the United Nations Framework Convention on Climate Change. It's been around since 91, 92, was ratified without a single opposing vote by the Senate. It's really a fundamental piece, the fundamental piece of international law and climate. It is definitely a kind of zealous campaign. I think it's a minority effort, even within the sort of Republican side of things. But here we are, and we're going to litigate it aggressively.
And there's new efforts. It's sort of the flood the zone thing. Now the Mercury rule is also being undercut right now. I think this has just been in the news the last 24 hours.
Rescinding the Biden administration's strengthening of the mercury and air toxic standards. Yes.
Yeah. Jonathan, do you have any quick reactions on to that? And then Gene, I want to ask you some questions.
I mean, I think as a descriptive matter, I agree a lot with that. I mean, there are things I think that Sean and I would disagree on in terms of, and even if we did agree, things that I don't think he'd want to agree with me on publicly while he's in litigation. But as a descriptive matter, I think we agree on that, and that one of the things that I think that I didn't hear him mention, which I think is just worth highlighting, is that there are some of the things the administration objects to, even apart from Massachusetts versus EPA, are kind of built into the way the Clean Air Act operates, right? So I think one reason they dropped the concern about the science, I think there are a couple reasons. One, the FACA violations that were confirmed in court, I think were a problem just in putting forward the report. There were questions of timing, right? The fact that the proposed rule was relying on the draft report before it had gone through public comment was just weird. You'd think you'd want the rulemaking to be based on the finalized report, not on the draft. But I think even more fundamentally, and I wonder if people internally in the administration got this, given the nature of the language in the Clean Air Act and the way that language has always been understood, it's not clear the DOE report did much for the administration's position, right? I mean, the language is that the administrator simply has to be able to reasonably anticipate that these emissions contribute to pollution that can be reasonably anticipated to threaten public health or welfare. We've always understood that language to be precautionary. The final rule tries to reinterpret that language in ways that allow the administration to input their own view of foreseeability. I think that has other problems, but the way the Clean Air Act is written, the administration the EPA is not asked to decide, is climate change catastrophic? It's not asked to decide, are there offsetting benefits? It's not asked to decide whether regulation is cost beneficial. So even if you accept the views of the DOE report that certain parts of climate change for the United States may not be as severe as some people may have said 20 years ago, or as some model projections say, or as RCP 8.5 would suggest, or whatever else, that's not enough to justify reversing the endangerment finding if your argument is based on the science, because there's still plenty in that report, in the mountains of research that's been done, that a reasonable observer would look at and say, yeah, I can reasonably anticipate some threats to public health and welfare based on that. And whether, if it increases crop yields or something else, I mean, so what? We've never understood the Clean Air Act to suggest that you do that sort of analysis the administration wants to do or says it wants to do. And so I think that's why they had to set the science aside, even if they hadn't had the FACA and other problems, and why they've resorted to a lot of these kind of clever arguments, which, last thing I'll say, would have worked a lot better for them in a world in which courts would defer to the way an agency makes sense of a complicated and potentially ambiguous statute and statutory structure, i.e. in a Chevron world. But we're not in a Chevron world. We're in a world where we're supposed to take what is the best interpretation of the statute and of the meaning of the words, not what the agency thinks works best for it. And on top of that, Loper Bright told us, and if there are prior statutory interpretations that the courts have blessed, we're not gonna disturb those. And that makes the whole project that the administration is engaged in, I think, very aggressive, very high risk, very at odds with, you would not counsel a client that this is a kind of a sound, likely to succeed legal strategy. And you would say to a client, if this is the position you want to take, fine, we can take it. But this is not the way we maximize our odds of winning.
And one thing, Jonathan, that's in a couple of the pieces you wrote is, I think it was in your pieces, this idea that they want to get something done before this president is out of office, and for this court as we know it.
Well, I think it's just for this court, and one of the New York Times pieces I know raised this issue as well, right? So I mean, we all know that rulemaking, especially for big complex environmental rules, is not a quick enterprise. It takes a new presidential administration months, sometimes a year and a half, 2 years before they're really kind of hitting their stride in terms of finally making the policy changes that they want to make. And if they're big and they're consequential, they're going to be litigated. And I think the current administration is aware that if the litigation isn't done, a future administration can drop its defense of the rule, can confess error, can tell the courts, let's just put a pause on this because we're going to reconsider it. And so I think they feel they're on the clock, that they want this to get to the Supreme Court before the Trump administration leaves office, because they need to be the ones in charge of defending it, and to be there to defend it. And that, I think, may that put time pressures, and I'm I'd be curious what Sean thinks on this as well. There are parts of the final rule that I read that I think, assuming that what they're trying to do could have handled a bit more time and effort. Like, there are some things that seemed a little too, it seemed like a bit of a rush job, or things that needed a little bit more work to finesse more than they did. But
well, I'd love to hear
information on that.
Sean, any thoughts? And actually, Jean, I want to ask you now if you have any questions for either of them, or
yeah. Well, I mean, so I'm curious about the Supreme Court as a protagonist in all this. I mean, we've heard, we know that none of the justices currently on the Supreme Court were in the majority opinion in Massachusetts versus EPA. There's this idea that the court has changed, moved strongly to the right, that maybe this is an opening to overturn Massachusetts versus EPA. I wonder, I mean, reading the tea leaves for the last year, is there any possibility that the Supreme Court doesn't take this up at all? Do you see? And what do you think it will do? And I guess, and I'll credit my colleague, Leslie Clark, with this question. She wondered if, today we had the tariff decision. I guess it mentioned major questions doctrine as part of the reason for, part of the unpacking why they were, ruling against the administration in this case. Are there any indications that this really won't go the Trump administration's way? And could you be specific about how that could unfold, I guess?
I'm happy to take a shot, and then Jonathan can clean up. So I think, Massachusetts, first of all, found that the language of the Clean Air Act was clear. So it wasn't based on ambiguity or deference to the agency. It said that this statute applies to greenhouse gases, and then it formulated EPA's responsibility in a way that I think is very inconsistent with what EPA is trying to do now. The other thing is Massachusetts discussed the Brown and Williamson case involving FDA regulation of tobacco. That was basically a sort of major questions doctrine before the name, where the court kind of said this is too big a thing, and the language is not clear enough. This would involve regulation of this huge industry that Congress has subsidized and all this stuff. And the Massachusetts court said that analysis really does not apply here, and there's no reason to think that the regulation of pollution from cars would, have that kind of sweeping impact. And so it's sort of, the court often says that stare decisis, the obligation to kind of honor precedent, except in really extraordinary circumstances, is especially strong in the case of statutory construction decisions, because Congress can always step in and change what the court has done or how the court has read things. And I think that is a principle that all the justices would agree to. So I think there are a number of ingredients that make this. I mentioned the fact that the endangerment finding and regulation under it has been in place now for a long time. And that distinguishes the cases where the court has applied major questions. So I think that there's a lot in the way of an effort to try to overturn Massachusetts or apply major questions sort of in this kind of unusual backward-looking way. I don't know. This is obviously an important issue. Would not hazard whether the court would deny cert if the DC Circuit were to overturn this and say you're just sort of violating the pretty clear holding of Massachusetts. But I do think there are very strong arguments that don't depend on justices being, sort of temperamentally enthusiastic about federal regulation of greenhouse gases.
Yeah, I agree with much of that. Let me just a couple things. One, as Sean mentioned, stare decisis concerns are greatest with statutory interpretation decisions, and the justification for that is that if Congress thinks the court has gotten a statute wrong, Congress can revise the statute. Stare decisis is less strong when we're talking about prudential doctrines and in particular constitutional decisions, because especially in constitutional decisions, the court's the only entity capable really of correcting its prior mistakes. And the court has, I think, been quite consistent about recognizing that distinction. Something else I would note, and it's people are often surprised by this, but since John Roberts has been Chief Justice, the court actually overturns its prior precedents less often than any prior post-World War II court, and it's not particularly close. I'm on record saying that I might be surprised if that trend continues, just because even if by the numbers alone, a 6-justice majority creates a lot more ability to reconsider precedents than a 5-4 court. But by the numbers, the court overturns precedents less often, and there are multiple justices on both the right and left who clearly care about that. In this particular context, in the UARC case, the Utility Air Resources Group case, the court could have reconsidered Mass versus EPA if it wanted to. There's even a pointed oral argument where the Chief Justice asks one of the advocates to make clear that that's not what they're asking the court to do, and has a comment that kind of suggests, don't ask us to do that, and instead give us a way to distinguish. And I think there are ways to kind of replay the UARG playbook if the goal is to simply close the door on future regulation of greenhouse gases under Section 111, as the administration has proposed, or to take away the idea that Section 202 regulation can be used to really, drive a shift towards EVs. I think there are ways of doing those sorts of moves, and the major questions doctrine can be helpful there, particularly on the latter. I think trying to do it here, I think is really unconvincing, which is why a lot of us read this and say, yeah, you're trying to distinguish Massachusetts versus EPA, but no one really is going to buy the way you're distinguishing it. So you're really asking the court to overturn it. But I think, are there 2 or 3 votes to overturn the statutory holding of Mass versus EPA? Probably. Are there 5? I think that's a riskier proposition. I mean, I can read the rulemaking and see how 5 might try and get there. I mean, there are a couple points where I think the arguments that the administration makes would need to be supplemented or improved to quite get there. But it is a big lift, and it's a bigger lift than kind of going after the various greenhouse gas regulations on the books one by one would have been, even on just looking at the judicial review side of things, right? Asking the Supreme Court to say that power plants no longer contribute significantly for purposes of requiring regulation under 111 is a much lighter lift than saying we're going to treat 202 as if the word significantly is in there, which the EPA is doing throughout this, and do something that it's hard to square with Mass versus EPA or throw Mass versus EPA out. I mean, that's just a much bigger ask. And one reason they maybe not take cert is if they just don't want to do that.
This is really interesting. Sean, actually, there's a question that came in. It's a very sort of discreet one for Jonathan Adler. Do you disagree with any government regulation to curb climate change, Jonathan?
I mean, I'm on record saying what I would do to address climate change. My view in general is that we make reduction of greenhouse gases globally significantly easier and less expensive, then the regulatory battles become much less of an issue, and that we should be focusing more on that. I would prefer something like a revenue neutral carbon tax combined with policies that are really designed to expand the horizons of innovation. And I think that that's better than using regulation. If we're going to have federal regulation, I would like it to be, clearly authorized. I disagreed with Mass versus EPA, the first 2 holdings of Mass versus EPA when it came out, but don't think it should be overturned because I think statutory stare decisis is important. So that's the thumbnail of my views on those questions.
And actually, an inverse way of looking at that is that there's very little evidence that regulation has done anything to change emissions trajectories, even within the United States, or maybe.
Yeah, although I'm familiar with that claim, but we don't really know what the counterfactual world would have.
Right.
So I don't know. But yeah, I mean, I know the arguments that are made that you look at the trend lines and it's hard to identify, how much of a wedge did given regulatory things do. To me, that just highlights why we really, we've been a lot more successful at using regulation to drive the implementation of adoption of things that we kind of clearly know how to do. Right. I also think if we're thinking globally, we're thinking about the rest of the world, we really need to be thinking less about what we do in the United States in the next 10, 20 years, and what are we going to do so that the world has access to cheap, affordable, low carbon electricity and energy.
Absolutely.
And,
I couldn't agree more.
I would love an administration that came in and said, we think this regulation is cumbersome and burdensome and costly and triggers litigation, and here's what we would do instead. Obviously, that's not the current administration's approach.
No. Well, as we were just saying a few minutes ago, even on the kind of old-fashioned pollution, that does have discrete and regional effects, they seem to be trying to roll back things just in the same way, which gets back to the white whales and how much of this is performative versus realistic. Gene, other questions from you?
Yeah, I mean,
Well,
both of you talked about how big a risk this is, and obviously it's going to take up, right, almost the rest of his term in office with litigation. If we assume that the Supreme Court will take it up, I mean, it's going to be at least a couple of years before there's a decision. What is the risk? What happens if? I mean, is this reading, too far into the future? It might be, but I mean, is there any possibility that the Biden rules spring back into life, or that basically this undoes the entire deregulatory process because this fails?
Sean, any thoughts on that?
I mean, that has been one of the reasons that industries like autos and power plant owners have opposed these sort of fundamental attacks on authority is regulatory uncertainty. And I think I would quibble with the suggestion there hasn't been progress, at least in those areas. Obviously, the power plant rules never went into effect, but I think the trajectory, and I think there was an understanding that regulation's coming and that cleaner generation is more likely to fit well with the regulatory structures that we will have in the future, and that has helped us. Our power emissions have gone down a lot, and the Trump administration is making a valiant effort to reverse that, but I think that will not succeed because the economics are now so strong in favor of cleaner generation. And then in cars, cars are a lot cleaner, and including on greenhouse gases, and that's partly because of federal and California regulations. So I think, yes, I mean, this is a big gamble just with these industries, because it unsettles what has been in place for many years, and it makes a promise that I don't think the administration is going to be able to deliver on, of sort of no climate mitigation regulations for the foreseeable future. And I don't think that's realistic. I think these companies who are active in multiple nations, like, this is not what they're going to be seeing elsewhere. As we know, China is making EVs that are cheaper and that are threatened to kind of dominate the market. So I think that the entire direction is not wise from the perspective of supporting American industries going forward. And what happens in this litigation, it's now a huge uncertainty for industries that have to plan many years in advance.
There's a comment that came in from Ivan Alzupo. This is way beyond my technical capacity. Avoidance by denying certiorari. Yeah, thank you. Seems to be a pretty common out for this court.
Well, I mean, in general, the court doesn't take a lot of cases, and the general understanding is that the justices they're not a court of error correction, and so that the importance or significance of a case and the need for Supreme Court attention to it has to be more than the justices think they might have decided differently. And when you have big environmental regulations that are only subject to review in the DC Circuit, you're not going to have a circuit split, which is one basis upon which the Supreme Court's going to accept a case. And so the court has to be convinced both that the regulation at issue is of sufficient importance and that the sorts of questions it raises are of sufficient importance to take it. Usually, we think that means that if an administration has a regulation struck down and it asks, that there's a high likelihood that the court will take it, but it's not guaranteed. We've certainly seen examples of administrations losing the DC Circuit and saying, please review this, and the court's refused. And as I think was already noted, the court has been asked to consider endangerment before, and it hasn't. That's a possibility we we would certainly want to think is real. One question I had for Sean, I'm kind of curious his thoughts on is, the administration has its Section 111 rule, or I guess its proposal, right? That hasn't been finalized yet. So I guess, there is some potential interaction between this and that rule. They aren't doing a separate 202 rulemaking. They've folded it into this, and they claim everything is severable. But my read is that although they say that as a way of saying, look, we just have to win on one of these arguments to get rid of endangerment, it still looks to me like it's not clear that they've really preserved a way to lose on endangerment but still repeal the 202 rule. But I'm not, I might be missing something, and that would seem to kind of increase the risk, whereas a smarter legal strategy would have perhaps been to do what they did with 111, which is say, we're going after endangerment because we hate that, but we're also going to have these separate rulemakings that are sufficiently separate that the courts will see them as standing alone. And here, it seems by pushing them together, they're actually increasing their risk in that regard.
Right. That seems right. So the statute says if you find endangerment, then you must regulate. The agency could say we no longer find endangerment, so we can't regulate. That's what they're saying with this rule that's out about motor vehicle emissions. They do not have a basis for saying, even if we still found endangerment, here's why we would repeal these standards. They just say that the standards fall because the endangerment finding falls. And if they're wrong about the endangerment finding, then they don't have anything to rely on. With power plants, they have alternative rationales, one of which is maybe we'll find there's not a significant contribution to pollution that endangers. But we might also find just that the rule is not technically feasible. So we don't have to do anything with endangerment. That's a little bit more conventional, kind of deep in the weeds of in this case, carbon capture and sequestration technology. And if they did that, then either as a freestanding thing or as a separate thing, that would at least give rise to arguments that, well, even if we're wrong about endangerment, we can rescind the regulation. So yeah, this is a big bet on the sort of first step in the motor vehicle context.
Right. And then two thoughts on that. I'd love your response to. One, on this, it seems that's, I guess, what heightens that risk is, they hint at various points in the rulemaking that they view the way the existing rules push towards electric vehicles as the mobile source equivalent of what the Clean Power Plan did. And, I think we can kind of understand what that argument would look like, but it's a separate argument and they don't ever really make it. So they're not preserving that as a basis to go for the rule, which I think we just, but then on the way they've at least proposed going after the 111 rule puts a lot of weight, as you noted, on the word significantly, which seems to create problems for some of the arguments here, because one of the arguments they essentially are making is that, well, in the grand scheme of things, mobile sources aren't that big a contributor, and new mobile sources, new cars, which are the only things that we're really regulating, are an even smaller and declining share. And so therefore regulations aren't going to address the dangers to public health or welfare. Well, that sounds like a significantly argument, just in different language. And so it, from a legal standpoint, it seems that gives you and your team an opportunity to it's hard for them to make both arguments simultaneously because it highlights the textual difference in the two provisions of the statute.
Yeah, that seems right. I mean, we obviously don't agree about, power plants are huge contributors. They're the biggest stationary sources, but absolutely, as far as the statutory difference, the 202 does not contain the word significantly. It's just hard to say that motor vehicles, which are the single largest source category in the United States and would be, high ranked among nations if they were a separate, are not contributors at all.
Right, but it's the lack of even having the you can argue in court with the administration on what it counts as a significant contribution. In 202, that language isn't even there.
Right.
And the fact that, and for folks that don't do the legal stuff, usually a court will say, if we're looking at one statute and we have one provision that uses a certain language and another provision that's similar but omits that language, we assume that difference matters. And so the fact that we have an endangerment-like provision in 111 that says contribute significantly, and we have another provision that just says contribute, the normal way we interpret a statute is to say that significance is required in one place and mere contribution by itself is enough in the others. And it's interesting to me that they would make an argument that opens itself up to such an obvious counter argument. I mean, it's odd. That strikes me as odd.
Although it's consistent with some other Trump administration moves in completely different arenas.
For sure.
Public health, vaccination, where there's no argument and they just plow ahead. So I don't know what that signifies.
Yeah.
On the power plant rule, of course, they put the proposal out before the endangerment finding. It doesn't actually reference the endangerment finding head on. It has this sort of endangerment light argument, about, causation and trying to apportion what the power sector, contributes. Are they going to have to do something to tweak it because the endangerment finding came out and was, finalized in the interim? I mean, are they going to have to repropose or some part of it, or, do something to, account for the fact that they've made this big regulatory change? And might that add time to the whole process?
Right. I don't know what they have in mind. It does seem like they haven't proposed, an equivalent rescission for power plants, and that they would need to do something else. But I don't know what they're thinking. And yeah, I mean, this is such an aggressive rule that the motor vehicles. It's not clear. And then there's yet another important source category of oil and gas, which also is another Section 111 rule. Methane is the main greenhouse gas there, and that's another one that they are planning to take some kind of actions, but it's not clear what.
And they're actually, in that case, planning to keep something in place, something, revised rather than repeal. But how can they do that if they've gotten rid of the endangerment finding and they're saying that methane isn't dangerous? Would they have to do VOCs instead of methane, or can they, write a rule for methane absent a finding of endangerment?
Good question.
I'm going to answer these questions.
Yeah.
There's one thing we haven't actually discussed yet, which is in a story that you had up today with your colleague Leslie, Jean, which is how these sort of blowback in terms of risk for companies. Can you just talk about what's in that story, and then we can close out with any other
Sure.
key takeaways?
I mean, these are the people I usually call for that. In fact, yeah. So I'm sitting here kind of summarizing the things that I've talked to them about. But, I mean, so actually, why are you having me summarize it when you have Jonathan, who is the person?
Yeah, okay.
Yeah.
I mean, there's a lot there, right? So, I mean, if Massachusetts we go back to the beginning of climate litigation. The general assumption was that if EPA has authority over greenhouse gases, then federal common law suits against on climate change are hard. But if it doesn't, then they have more running room under a doctrine called displacement. So there is very much if the Clean Air Act goes away and Mass versus EPA is repealed on this point, is there a way to maintain displacement to prevent federal common law suits? And unclear if that's the case. So that's one risk. Second risk is the administration has a lot of broad preemption arguments that I think as a matter of preemption doctrine are wholly unpersuasive, that various state tort suits, some on nuisance, some on other theories of consumer protection and the like, are somehow preempted by the existence of the Clean Air Act or constitutional structure. those arguments certainly become weaker if we no longer have a Clean Air Act that either in intent or practice is dealing with greenhouse gases. And so, asking the court to overturn Mass versus EPA is the real tipping point, I think, for both of those arguments, because those arguments are really about whether or not Congress has occupied or entered the field more so than whether or not there's kind of technical complexity. The next question, which is of course of interesting, is that the preemption of California and state vehicle standards is premised upon the emissions being regulated. And so there is also this question that they will have to finesse about things being still subject to Clean Air Act regulation, Sean may have thoughts on this as well, or if this gets to the Supreme Court and if they are going to take a shot at a Mass versus EPA, are they also then going to take a shot at the holding about the extent to which the Clean Air Act overlaps or conflicts with energy laws dealing with fuel economy as a way of trying to maintain preemption of state climate standards. But it's doing this by going after endangerment and putting Mass versus EPA potentially on the table creates these scenarios in a way that simply going after individual source specific regulations would not. That's the short version.
Wow. Well, there's a lot to keep track of here going forward.
The Supreme Court is currently considering a petition for certiorari in the Suncor case out of Boulder, Colorado, which is one of the state tort law cases. The court has consistently denied cert petitions in these cases before, both on some technical procedural questions as well as on the merits. This case has been relisted a couple times, so it's possible it could be granted for next term.
Interesting. Well, I really appreciate all you coming on today on a Friday in a very busy moment in history to talk about this epic battle, the latest kind of maneuvers, some of which certainly sound more theatrical than based in law, that in ways that could be manifested in the next few years. A lot of lawyers are going to have a lot of fees accrued through this, but the emissions of greenhouse gases, as Jonathan and I agree for sure, are really a function of many other things that are going on in the world. A focus on innovation is and on the reality that industry wants consistency is something that's come out here. This whiplash, perpetual whiplash on these climate rules is something I've written about before, and that the idea that I think Jonathan and others have expressed in their writing also, that Congress is the one place that can clean this up, but looking at Congress these days doesn't seem very encouraging when it comes to
we might get permitting reform, maybe.
Yeah, right, for and nuclear energy, NRC, regulatory streamlining for sure, Nuclear Regulatory Commission.
And
so,
I would say, if there are a bunch of tort lawsuits all over the country against big emitting facilities, and that becomes a real nuisance to business, might there be kind of a drumbeat at some point to clean that up with legislation? There hasn't really been, a passionate, strong, demand certainly on the part of industry ever for, an amendment to the Clean Air Act. Could this create, the platform for that to happen? Maybe.
I mean, I think there have been periods where the larger players in industry at least would have taken some sort of deal that both would cap regulatory burdens, particularly with regard to stationary sources, and remove litigation risk in return for something like a carbon tax or whatever else. Whether that sort of deal is the sort of thing that could be cobbled together in the future, I think it's hard to know. Certainly if the court doesn't do something to preclude or preempt the state tort cases, I do think that the opportunities for some kind of larger deal to create a clear legal environment for climate change and greenhouse gas emissions is there. But I'm not gonna. What that would look like and who would need to be at the table for that, I'm not entirely sure.
And what balance in Congress?
Right.
Yeah. Sean, any last thoughts from Sean Donahue?
Yeah. I mean, I think in addition to the enormous uncertainty that Jonathan described really well, and a whole bunch of different areas, including nuisance suits and preemption, if this were to hold up, I mean, I think there would be a lot of demand and energy sort of on the climate action advocacy side of things. I mean, people have thought that the Clean Air Act was there. That's been the focus of a lot of policy, energy and supporting regulation of the major sectors under the Clean Air Act. And so, what that looks like demand for new state and local and federal policies, we don't know yet, but it would certainly be just a hugely significant change in the politics.
All right. Well, this has been a really a great little primer, leading with lots more questions emerging, which is always the reality on issues like this. It's great to have Gene Chemnick, a climate reporter at ENE News, Politico, Sean Donahue, a lawyer representing the Environmental Defense Fund, and others in what will end up in the Supreme Court almost assuredly case around the elimination of the endangerment finding by the EPA, and Jonathan Adler, longtime professor of law, who's now at William and Mary. And thank you all for your time on a busy Friday with tariffs and reversals and all kinds of things going on. Maybe an attack on Iran, who knows what. So stay tuned. Everyone out there, you can share the show we're just completing as soon as we're done. It stays archived. Send me questions or ideas for future shows using that distracting information at the bottom that scrolls by like the stock market. Take care, everybody. Sustain what is done for the day.
Thank you.